My name is Marina Gruber. I'm a partner at Procopio, practicing labor and employment law. I'm a litigator and a counselor, and I litigate all throughout the state of California. I'm also licensed in the state of Washington, and I'm based out of our Palo Alto office. This is a kind of work and topic that's really near and dear to my heart. In undergrad at UC Berkeley, I actually worked for a startup. And so I have a real appreciation for how hard you all work and really how hard it is to build a business in California. So for this reason, I'm really happy to be speaking to you, and I really enjoy working with and helping startups and small businesses, and it is a pretty significant part of my practice. So I like to think that I understand a little bit about the challenges that you face from an employment perspective, and I do like to hope that I can offer you some guidance and some empathy when it comes to how challenging it is to comply with California law. So with that, let's get started. We're going to be talking about really what I think are 7 things that I'd like you to be thinking about as you work on growing your business and dealing with the challenges of California law. So misclassification, both independent contractor versus employee, and then exempt versus non-exempt employees, wage and hour compliance questions for specifically your non-exempt employee workforce, leaves of absence, and kind of the interaction between leaves of absence, which I think is a particularly tricky subject, employment handbooks and arbitration agreements, and record keeping and notice postings, required trainings, and some litigation avoidance tips. Because I imagine for everyone here, litigation avoidance is pretty high on your goal list. So let's talk about misclassification first. So when is someone an employee? So under the law, there is going to be a presumption that someone who is performing services for you is an employee. It is going to be up to you to prove otherwise. And it can be difficult to establish that someone is not an employee. And I want you to be careful with any kinds of classifications that you use that are not employee-based. So this is unpaid interns, volunteers, independent contractors, anything like that. So volunteers, just one note on that, are really only going to apply if you're a nonprofit. So for any businesses out there that are for-profit entities, volunteers aren't going to apply to you. Unpaid interns are also very difficult to establish. There's a pretty significant test that you have to meet in order to have someone be an unpaid intern. And really, the primary benefit for the internship needs to flow towards the intern, not to you. And typically, when you have an intern, it's because you really need some kind of work to be performed for you for your benefit. If you have interns, be really careful with that. Talk to counsel, have those agreements reviewed. And make sure you're meeting all the tests that you need to under state and federal law. There's a 7-factor test under federal law, and then what's called a primary beneficiary test under state law. So pretty complicated thing to meet for interns. We're going to talk about independent contractors more at length in a moment here, but for each of these different classifications, there are a number of risks. And so I'd just like you to be careful with any kind of classification you're making for the people performing services for you. I want you to also keep in mind your contracts do not control whether or not someone is an employee. Because you might be thinking, well, I have contracts for all these people, so I should probably be fine. It's not like we just shook hands and said, okay, you're a volunteer or you're an independent contractor. We have an independent contractor agreement. Well, the agreement is only worth the whether or not it complies with the law. So if you have an independent contractor agreement that has provisions that are unlawful or provisions that transform someone from an independent contractor to an employee, then you might get yourself in a heap of trouble. For example, inventions assignment agreements will typically have works made for hire provisions. They're in every single employment agreement that has an inventions assignment provision in it. But if it's in an independent contractor agreement, it transforms that person from an independent contractor to an employee automatically under our statutory codes. for the purposes of unemployment insurance and workers' compensation. And it could transform them to employee status for other purposes as well. So your contracts might not be helpful for you. And in some cases, they might be really detrimental if you're trying to establish something like independent contractor status. And I also want to note that even if you're not controlling the details of someone's work, an employer and employee relationship can still be found, even if you're controlling the work as a whole, or the work that someone is doing is really integral to your operation, and the work that they're doing doesn't really necessitate control. They might be doing something where limited oversight makes sense, but that doesn't mean that they're not an employee. Also, if someone is doing something for your business that employees also do, it's going to be very difficult to say that the person who's an independent contractor is properly classified when the person next to them is an employee. Metaphorically next to them, probably not actually next to them, unless you actually do physically have people sitting next to each other doing the same work. So we've got a presumption of employee status. That's the reality. So when is someone properly classified as an independent contractor? Well, in California, we have something called the ABC test. You've probably heard about it. It was pretty big in the news when it was launched. There was a pretty big case that came out called Dynamex. And then we got some statutory provisions related to the ABC test following that. In order to properly classify someone as an independent contractor under the ABC test, you're required to prove three things. So the person has to be free from control, both under the terms of the contract and in fact. So this should be highlighting for you that you will need contracts for your independent contractors if you don't have them. And the work that they're doing, even if your contract says, we are going to treat you as an independent contractor, we're not going to be monitoring your work, that's how it actually has to play out in reality. You can't be overseeing every aspect of their work and meet the first requirement of this test. The second prong is that the worker needs to be performing some services for you that are outside the usual course of your business. This is actually the hardest part to meet for most independent contractors, because our case law and the opinions that we see, and in other jurisdictions that have been using the ABC test, which California sometimes looks to, a lot of work that contractors have historically provided has been determined to be within the usual course of the hiring entity's business. So this is the thing that actually kills a lot of independent contractor relationships and upended a lot of prior independent contractor statuses when this test was launched in California. The third piece here is that the worker needs to customarily be engaged in an independent trade or business. That is, you can't bring someone on and call them a contractor and they've never done this work before, right? They don't market themselves as a contractor providing these services. They don't have a license for this work. They've never done it. And you're just bringing them on and you're going to perhaps train them in this work and call them a contractor. That would not meet the requirements for this piece. So one other thing I wanted to mention for the ABC test before I move on is that really the most likely people that we would see as properly classified as independent contractors are going to be services vendors who come in and perform isolated services for you. So these are going to be, electricians who come in and fix something in your physical location, plumbers, things like that. Somebody who comes in and hosts an event for you, a workplace retreat that you host at your work site, something along those lines. Anything that is closely aligned to what you do as a business is going to be under heavy scrutiny. So just be very careful. I'll also note that there are some services that people provide that are exempt from the ABC test. And so some examples of those might be like a licensed CPA might provide services to your business, but that person would still have to meet the former Borrello test, which is itself a pretty strenuous test. And that was what we had before the ABC test. And that weighed and looked at a number of different factors, actually 11 different factors to determine if someone's an independent contractor under that test. So if you have independent contractors who you're not sure about, or you just want to have some of these things looked at, please talk to an attorney, find someone to work with you on it, because it's really important and If you get it wrong, it's very expensive, very costly. And if you get sued for these kinds of issues in California, you have to pay the attorney's fees for the plaintiff, the other side, which would be like an independent contractor who you potentially misclassified. If you lose on that kind of case, you have to pay their attorney's fees. And even if you win, they don't pay your attorney's fees. So it's very expensive. So let's move to the next misclassification question. So one of the things that I get quite often is maybe not everybody's classified as an independent contractor, but everybody in the business is classified as exempt. And I understand that, there might be a temptation to just classify people as exempt, pay them a salary, and kind of wash your hands of it, right? And say, we don't want to monitor too much here. We want to focus on building our product or developing our technology or working with our stem cells or whatever it is that you're doing that's wonderful and important. But you need to be wary, I should say, and aware of this issue, because as with the prior discussion on independent contractor versus employee misclassification, there is also a presumption that all employees are non-exempt and entitled to certain protections under the labor code and under California law. And it's going to be your burden as the employer to prove that someone is exempt from those requirements. That's what exemption for this purpose means, that someone is exempt from the requirements of overtime, meal and rest breaks, etc. There are two real primary tests that you have to meet in order for somebody to properly be classified as exempt. The first is a minimum salary. So as of right now, that minimum salary is $68,640. If you have any exempt people who are making less than that right now, you need to fix it right away, because that is a threshold issue. And if you are paying someone $67,000, they are not exempt. And all of the time that they've been working for you, they have been misclassified and they're potentially owed overtime, premiums for missed meal and or rest breaks, and you would just lose that case. So you need to make sure you're always paying the minimum salary, which goes up annually because it's tied to the minimum wage. So you have to watch that every year. You also need to pass what we call the duties test. Every single person who you have classified as exempt, there has to be some substantive basis for classifying them as exempt from the requirements of overtime. So the exempt classifications look at industry and what someone's doing, but computer professionals are really something that we'll see in wage order 4, which applies to a lot of office environments. I think it's probably going to be the most relevant one for a lot of you. But the exemptions we're going to see are executive, administrative, professional, computer, and outside sales. Those are the ones we're going to see most frequently. Executive is what you would think. Somebody who's in a high-level leadership role, they have the ability to hire and fire people, they have 2 or more people working under them, they're paid at least $68,640 a year, and their duties are high level. And the majority of their duties are high level. So if somebody does high level duties part of the time and not high level duties some other part of the time, that could potentially jeopardize their exempt status. So always keep that in mind for any of these exempt classifications. We'll talk about it a little bit more. Administrative, those are people who are paid the minimum salary and they do work that's directly related to management policies and general business operations. I often see this classification for people like office managers who have a pretty high level of authority, can even be executive assistants for the CEO or C-suite who have a high level of authority. They're making decisions, they know what all the policies are, and they're deciding policies, implementing policies, making decisions that are in line with those policies. And they really operate under pretty limited supervision. They report to the CEO or the CFO or whomever, but they have a lot of discretion and independent judgment on a day-to-day basis to decide what should be done in terms of running the operations of the business. A lot of different people might fall within an administrative exemption, but there's also a lot of case law on this exemption that has decided whether or not someone in a particular role is properly classified. So again, it's an important one to have reviewed and make sure that you have a proper classification. Professionally exempt employees are people like lawyers, people in the medical field, dentistry, optometry, architects, engineers, teachers, and accountants. These are all people who are licensed in these fields. So licensed engineers, those may or may not be the engineers that you have if you have a software engineer who's not licensed, but that person might fall, and typically we would argue that they would fall under what we call the learned profession exemption, which is part of the professional exemption. Computer professionals are typically IT or other personnel within the computer software field. They have to be paid a minimum salary that's much higher. It's set on a different basis. It's not tied exactly to the minimum wage the same way the standard salary basis is. So for your computer professionals, those people, as of right now, have to make $118,657.43 per year. That also goes up each year. Very important to monitor that as well, so that you don't have an issue about whether those people are being paid properly. Outside salespeople, also something that might come up for you, and so I wanted to include it. Those people need to be spending more than half their time away from your location. If they are an employee who is working remotely, then that means they actually physically have to be away from their home 50% or more of the time doing sales, like actually selling your products. So if someone is really doing the sales from their computer in your work location, they're probably not an outside salesperson. And, you would need to look at that and figure out if you have all of these people classified appropriately. I also want to note exempt status can change over time. So you might have someone who's classified as administratively exempt when they start, or over time they get promoted and you classify them as exempt. But if their duties change over time and they go from being an office manager who's running like literally everything for you when your company only has 5 people to your company now has 200 people and there's a COO who's actually running everything, that office manager may no longer be properly classified as exempt. So this is something that is not set in stone. The exemption status is not necessarily set in stone, and you would need to review it over time to make sure that nothing has changed. Also, as I mentioned before, the salary, you need to make sure that salary is going up over time if you have people who were paid close to whatever the annual minimum was. I want to also note that something I've seen pretty frequently is that founders who designate themselves as, founder and CEO, founder and CTO, or founder COO, something like that, and they don't pay themselves any money, that is also a problem. The requirement to be paid under the law applies to everyone. So I always tell founders and others that I'm talking to, if you can, please pay everyone at least the minimum salary if they're doing really exempt level work. So then you don't have an issue about them not being paid properly later. I've had cases where startups have a founder who then later is not necessarily demoted, but changes roles and then threatens a lawsuit saying I should have been paid more. When the business started, he didn't want to be paid anything at all. So someone can't waive their right to be paid. So everybody in the business needs to be paid either the minimum wage or the minimum salary. If you pay someone less than that minimum salary, they're not going to be classified as exempt. So they would be non-exempt, and you have to make sure that you're paying them at least minimum wage. And then that gets into other wage and hour compliance questions, which we're about to talk about next. So if someone is non-exempt, they have to be paid overtime for all hours over 8 in a day, 40 in a week, and they're entitled to meal and rest breaks. So, and they're also entitled to 1 day's rest in 7. So I think for a lot of the work that you're doing, you probably have people working really long hours. I know it can be a grind, but you're doing some exciting stuff. So just keep all of this in mind, because if one of the goals is to avoid litigation and be as compliant as possible, you need to sometimes be creative to get to those goals when it comes to compliance with the law. And you can certainly find an attorney to help you get there and do whatever you need to do to maintain compliance. So let's talk about wage and hour issues. And these are really things that are going to come up for your non-exempt employees. And when I say that, I just want to note that, again, to go to those first set of issues that I was talking about, these issues, wage and hour compliance, are going to come up for anybody who's misclassified as an independent contractor or anyone who is misclassified as exempt. Because if you have someone who you classify as an independent contractor, but they really should have been classified as an employee, you're not going to be able to retroactively designate them as an exempt employee. And so you're going to be in a situation where they're going to say, I wasn't paid properly and I should have been non-exempt. And so I'm entitled to a whole bunch of protections that I didn't get. So these things are really important, and a lot of it is administratively burdensome, or it can be burdensome. And so I think I'm trying to highlight these things for you now. So at least they're kind of in the back of your mind. As I don't know where all of you are in your life cycle. I don't know what your funding cycles are like, how many employees you have, anything like that. And so I just want these things to be kind of out there for you so that as you do grow and hopefully succeed, you've got them as things you're going to work on if you haven't thought about them yet. So some compensation or kind of wage and hour issues, clients issues to be thinking about. At the time of hire, employees are entitled to what's called a Wage Theft Prevention Act notice that says how they're going to be paid, how often the payroll is, and it has workers' compensation information. There's a standard form that you can Google on the California DIR website, and you can use that form, but you need to give it to all of your non-exempt employees at hire. Your paycheck stubs need to be in compliance with California law. This is really for exempt and non-exempt employees, but it becomes a much bigger issue for non-exempt employees because those are the ones that are much more likely to result in litigation over issues involving overtime and things like that. You need to pay wages regularly. So, one of the things that comes up with a fair amount of frequency are payroll cycles that are irregular or not having enough funding, and you really pay people once a month instead of twice a month. Those things will get you in trouble. If you can try to structure things in a way that takes that risk into account and pay consistently, that will help you avoid litigation in the long run. Because when you start having issues with how often you pay, it really does send up a red flag for employees. So anything that you can do to minimize those potential risks will be definitely in your favor. You need to make sure that you're classifying your non-exempt employees correctly and then paying them for all hours worked. So this means no off the clock work, or, you need to tell employees not to work off the clock. But if they do work off the clock, you would have to pay them. But you can't have a no overtime policy or something that says we don't pay overtime, because if someone works overtime, you have to pay it. And you want to be monitoring and paying for that appropriately. You need to be paying overtime at what's called the regular rate of pay for all hours worked over 8 in a day or 40 in a work week. Sometimes I see handbooks still that say 40 in a work week and they leave out the daily overtime, but California is a daily overtime state. So the regular rate of pay is not just 1.5 times whatever someone's standard hourly rate is. The regular rate of pay for a non-exempt employee takes into account all forms of compensation that they receive in a given week. So if someone gets a bonus or a commission, some other pay, that would need to be factored in to the regular rate of pay for them. You also, for your non-exempt employees, are going to need to be thinking about meal period and rest break premiums, which are 1 hour of pay for every missed meal or missed rest break up to 2 in a day. So you can have 1 missed meal, 1 missed rest break per day per person. And those issues can really stack up. I could do a whole seminar really on meal and rest break compliance and how to manage that. But you do need to have policies on that and deal with it. And we're going to talk a little bit more about meal and rest breaks just after this, but I just want to alert you to that being a really serious issue. One of the other compensation issues that I see quite frequently is the issuance of non-wage forms of payment. For example, RSUs, stock options, etc., instead of wages. You cannot pay someone only in stock and no money. You also can't pay them like half in wages, half in stock, unless you are meeting all those other minimum thresholds that we talked about. I see this pretty regularly. I know it's common, but it is not legally compliant. So if you're doing that, I just want to let you know that there is some risk there, because there is no ability under the law to waive your right to wages. Someone cannot waive their right to be paid under these circumstances. So giving them stock instead of wages is not going to work. You might be thinking, I'm probably okay. I have a payroll company that manages this stuff for me, or I use a PEO or an ASO to help me manage some of these HR obligations, and I'm sure they're on top of it. I have to tell you that payroll companies are not looking out for your interests. ASOs and PEOs might be looking out for your interests slightly more, but they also are not going to absorb liability for you, and they are not going to be as invested as you are in your business being successful. And they are not going to be looking for these kinds of details as to whether you're doing things correctly. And I also, in those agreements that you sign with those kind of entities, the third party administrative entities, they almost always say that you are going to indemnify them if they are brought into a lawsuit, meaning you pay their attorney's fees and the cost of any liability, and you pay your own attorney's fees, and they're not going to pay for anything, and they're not going to help you. So, even if you have some of these entities out there helping you, be really careful. Make sure you're talking to counsel and that you're reviewing these things, hopefully before someone complains. But if someone does complain, that gives you an opportunity to fix something, hopefully before there's a lawsuit. So meal breaks for your non-exempt workforce. Every non-exempt employee is going to be entitled to a meal period. If they work 6 hours, really a 5 or 6 hour shift, they're going to be entitled to a meal period. So they can't work more than 5 hours without being provided a 30-minute meal break. And that meal break must begin before the end of the 5th hour. So that means if someone starts work at 8 a.m., the meal period needs to start by 11:59 a.m. It needs to start before the end of the 5th hour. There's also a second meal period for someone who works a longer shift. So if you got a 10, 11, 12-hour day person, they get a second meal period. You can have a lawful meal period waiver for someone who works a shift that's scheduled for 6 hours or fewer. That needs to be in writing. You need to get that from a lawyer or someone to help you with that. I don't know how many of you out there have people who are working that kind of part-time schedule, but you might have someone who works, 4 hours a day every day. That person doesn't necessarily need to get a meal period, but you need to have a written meal period waiver with them. Meal periods are unpaid, but you can't make someone stay at the workplace. They have to have some flexibility in where they eat. You also need to keep records of meal periods. It's not that you just make sure these things are provided to people. You actually need to keep records. So your non-exempt employees, you need to have accurate time records that show punch in or when they start in the morning, a punch out for starting their meal period, a punch back in for when they come back from their meal period, and then a punch at the end of the day when they're done. The reason for that is it will be your burden to establish that employees were provided the meal periods they were entitled to get. You can have non-compliant meal periods for a few different reasons, but the primary ones we see are someone did not get a full 30 minutes. So it was a short meal period. So someone takes just 25 minutes. That's not a compliant meal period. It has to be 30. You can also have someone who has an interrupted meal period. So maybe they record 30 minutes on the clock, but the manager comes and talks to them and doesn't realize that they're on a meal break and then interrupts their lunch. That would be a non-compliant meal period, and they would be entitled to a premium. Or you can have people who just don't have a meal period at all. And if they don't record a meal period, they also might kick into overtime, right? So then you'd have to pay them for the time they didn't get a meal period. You'd have to pay them a premium, and they also might get overtime at the end of the day because they kept working through. So if a non-exempt employee does not get a compliant meal period, you have to pay them an additional hour of pay. That's the meal break premium. And those can really add up. And in the current kind of climate of California for these kinds of issues, it's very rare that you would have non-exempt employees who have never been paid a premium. Whenever we get lawsuits and someone has never been paid a premium, the plaintiff's attorneys on the other side are just salivating over that because they know that it will be pretty easy for them to establish that someone did not get fully compliant meal breaks. So these are things that you need to be thinking about as well. Rest breaks. Non-exempt employees are also entitled to rest breaks. Typically, you're going to have 2 per workday, and rest breaks do not need to be scheduled in the same way that meal breaks are scheduled, but they're supposed to be generally about in the middle of a work period. So if someone starts at 8, they take a 10-minute rest break at 10 a.m., they take lunch at noon or like right before noon. That's what you would expect to see. You're not supposed to stack them together either. So you're not supposed to have someone who takes a rest break, lunch, another rest break all together. It's supposed to give someone an actual rest time in the middle of a work period. Rest breaks are paid. And you're not required to keep a record of them. Depending on what your business is, it might be a good idea to generally schedule them or have some oversight for the non-exempt employees to make sure they're getting them. But I've only seen a few businesses over the years that actually kept a track record of the breaks, and that can kind of cut against you if you actually keep a track record of the rest breaks. So these don't have to have quite the same level of documentation that the meal periods do, but they also cannot be waived. Whereas a meal period can be waived in some circumstances, rest break cannot. So if someone has an interrupted rest break or they don't get a rest break, they can also get a premium payment for that. So you could end up with 2 hours of additional pay for someone who had a crazy day and didn't get a lunch and didn't get a meal, or didn't get a rest break, I'm sorry, and didn't get a meal. All right, so leaves of absence are, I think, as I mentioned before, what I consider to be one of the hardest things to manage, very challenging, and especially very challenging with small businesses or startups. You know, a leave of absence, there's an entitlement to them, but they can be very expensive for your business to absorb and difficult administratively to manage if you don't have somebody internal to do the documentation, to know how the policies should be enforced. These are a frequent source of litigation, I do have to say. It's very often that somebody has a disability accommodation need in the form of a leave, or they're going out on parental leave or something else, and then the process is not handled as close to the letter of the law as maybe we would like, and that results in a lawsuit. And these lawsuits have a very high nuisance value. They're very expensive to settle. If you have somebody who left a year and a half ago and they bring a lawsuit and their manager has moved on to a different company, nobody remembers what was going on, it can be very difficult to litigate these, and it's expensive on your part to litigate them as well, because you have to pay for the attorney to defend you, and you would have to pay the fees for the other side as well if you lose. So the things that I see most commonly, or, you know, what I've seen as the interaction issues that come up most commonly, involve paid sick leave, the California Family Rights Act, and or the FMLA, Family Medical Leave Act, which is the federal version of the California Family Rights Act, pregnancy disability leave issues, and disability accommodation. Paid sick leave, you need to make sure that you've got a written policy on paid sick leave. I have worked with a number of small businesses and startups that have unlimited PTO plans. Those can be implemented appropriately and lawfully. They also can be very dangerous for you because they can be hard to manage from just a vacation perspective. But when it comes to paid sick leave, you need to make sure that you're complying with all of the legal requirements for paid sick leave, even if you have an unlimited PTO plan. And that includes things like you can't ask for a doctor's note if someone says that they need to use paid sick leave, and, you know, they have to get the amount of sick leave that they're entitled to under the law. You have to make sure that they're not disciplined for using their paid sick leave, and that the policy outlines for them what the paid sick leave can be used for. It's a really extensive kind of number of things that paid sick leave can be used for and how it works. CFRA applies to all employers with 5 employees or more, and that is job protected leave for 12 weeks. And it can be for a whole number of reasons. We see a lot of it for baby bonding. After somebody has a baby, you know, any of your employees can use CFRA leave for bonding purposes. If you have 50 employees within a 75-mile radius, then you also are obligated to provide leave under the FMLA. Some types of leave run concurrently, that is at the same time for CFRA and FMLA, and some don't. For example, if you have an employee who is pregnant and is disabled in connection with the pregnancy, and I use that term a little bit more loosely, or not in the same way that you might think of as in disability, but when after someone has a baby, the first 6 weeks is presumed to be disability. That time runs concurrently with FMLA, but it does not run concurrently with CFRA for the purposes of California. So you can have a lot of different things that run at the same time, and you have to be really careful to provide everything that you need to provide. Pregnancy disability leave, PDL, also is going to apply even for small employers, and that is up to 4 months of leave for somebody who is disabled in connection with a pregnancy. So it can be before and after the delivery of a baby. And that's something that you need to make sure that you're providing and you have a policy. Appreciate that sometimes that might be difficult to do, but that is something that also comes up with a lot of frequency, especially when it's the first time maybe that you have a pregnant employee and you're trying to figure out what kind of leave they're entitled to and what you should be doing. The last one that comes up quite frequently is just standard disability accommodation. If you have 5 employees, you need to be engaging in the interactive process. And again, this is something I could do a whole webinar on, the disability accommodation process. So a leave of absence can be a disability accommodation. And so if someone has, a serious medical condition and they need to take off 3 or 4 months of leave in order to have surgery and recover from that surgery, that can be an accommodation for their temporary disability. And you have to engage in the process with them and their medical provider to figure out how long of a leave of absence they need, and then figure out if that's something you can accommodate. And in order to meet all of your duties under the law, you need to have that process pretty well documented. And if it's something that really the business cannot accommodate, there's a whole test that we have to meet in order to show that it would be an undue hardship to provide that accommodation. And that is very frequently litigated and a source of pretty expensive litigation because, as you might imagine, it's a pretty fact-intensive process. And, if you terminate someone after they've told you that they're disabled and they need a 6-month leave of absence, it'll be very expensive for you to resolve that dispute. But it can be very difficult when you've got an employee or, a workforce of 10 employees and someone who's pretty key to what you're doing needs to take a 6-month leave. So if you get into these kinds of issues again, I think it's very important that you talk with counsel early and often about what you should be doing and how to manage it. Employment handbooks and arbitration agreements. So employment handbooks really, for all intents and purposes, are required under California law because there are a number of policies that you are required to have and disseminate to your employees under the law. You could have them, just standalone policies on your intranet or something like that, but it's really much more efficient to just have an employment handbook. We do these all the time and we tailor them for businesses that have 10 people versus a business that has, 60 people, because different obligations kick in depending on how big your business is. But you really do want to have a handbook, and it's not a one-time, one and done, you don't have to revise it kind of situation. As with all of this stuff, the law changes, things evolve, and in every single lawsuit I have ever had, one of the first requests that we always get from the other side is for a copy of all of the handbooks that were in force during the time that the person was employed. So if you have handbooks that are 15 years old or 10 years old and all of the policies should have been updated, it does not look good for you because it's more difficult for us to say that you were doing what you needed to do, because we would have to say, these are the policies that were in place, but you didn't follow them. You actually complied with the law. As you might imagine, that gets hard to argue and it makes it look like you weren't complying with the law if you didn't have something that was up to date. Handbooks also give you a chance to present your culture and values to your organization. So you can modify handbooks to really talk about things that are important to you or the things that you value. You notify employees about all of their rights and obligations. You might have internal company policies that are particularly important to you. I also think they're a good opportunity to reinforce for employees the importance of protecting confidential information, things like data security, proprietary information that they're going to come in contact with. So there are just lots of things as you grow that you want to make sure are included in a handbook to help you defend against future legal claims and make sure that employees know what they need to be complying with. And I always say, and it's our practice here that we try to get some acknowledgement from the employees that they understand that the policies apply to them. They have a duty to read the handbook and comply with it. You can do that electronically. You can, do it in paper. You can have whatever kind of system that works for you, but something that says everybody got this and they understood and they knew that it applied to them. Arbitration agreements are also something that we typically advise employers to have, particularly if you have a large non-exempt workforce, or if for some reason it really makes sense to you to not want to have litigation be public and in court. Arbitration agreements can be favored to avoid class actions because you can have what's called a class action waiver. And so that means somebody can't bring a lawsuit on behalf of all of the non-exempt employees and try to seek meal and rest break premiums for everyone. They can only bring their individual claims in arbitration. There's generally a perception that arbitration is quicker and fairer. I have mixed feelings on that. Sometimes it takes just as long to get to an arbitration hearing, and sometimes I feel like the arbitrators are not fair. I also don't know that it's always cheaper, and that goes to the burdens because in California, employers have to bear the cost of arbitration in terms of the actual fees of the arbitrator and everything that goes along with running the arbitration itself. The only thing that a plaintiff employee would have to pay is kind of an initial filing fee, because our case law has said that if you file an action in court, that's primarily what an employee would have to pay. And so they shouldn't be required to arbitrate their claims and pay for more than they would have to pay in court. Recently, we've had some arbitration invoices come in, and it's $100,000, $200,000 in advance of the arbitration for the arbitrator's expected time to run the arbitration hearing. So that's a lot of money that you have to be prepared to pay. There's some predictability with arbitration and how it's going to work, and it's not public. I mean, that is one of the things that is really beneficial, especially if you've got a race discrimination case or something else that it makes sense to have an arbitration and you don't want to get some really negative press on it. And there is some ability to control the costs, but like I said, it's a mixed bag for me on that. You can limit some of the discovery costs and other things that go along with litigation, but there's still a pretty high cost. With arbitration, you really have no appeal right. So whatever the arbitrator decides is what they're going to decide. That's what you're going to get. That can be disappointing, right? If you're in court and you get a bad decision, you can appeal it and perhaps get it reversed. If an arbitrator does something that's frankly kind of crazy, you might be stuck with it and it's really, really hard to overturn it. And that's just going to be your reality. And like I said, the costs are high and you're going to pay them. It can go on quite long. It can take 2 years to get to an arbitration hearing, and the arbitration hearings themselves can go on for quite a bit of time. You also might have a fight over enforcing the arbitration agreement before you even get to the process of being in arbitration. And so then you'll spend dollars just enforcing your arbitration agreements. So these are all things to just keep in mind. If you are thinking about arbitration agreements, it's just something to talk with counsel about, but it might be something that you want to implement just as kind of your onboarding and your practices moving forward to control some of your litigation. But it's also something that you might not need to implement immediately. Just talk to counsel. So record keeping, I know it's probably low on what y'all want to think about, but it is pretty important because when it comes to defending in a lawsuit, if you don't have good records, you're really going to be behind the eight ball. And it can be really hard to defend a case with minimal record keeping. You need to be keeping personnel files for everyone, records of the offer letters that you give out for your non-exempt employees. You need to have hours worked, records of their meal periods. You need to have records of vacation time. If you have a vacation policy or a PTO policy, if you have an unlimited PTO policy, it's a separate issue for which you should talk with counsel about how to manage that. But if you do have an actual vacation policy with an accrual, you need to then be keeping track of someone actually taking vacation. I know that that can be difficult when you've got kind of like a fast and furious environment, and you might have people who aren't putting in their vacation time, or they're around, but then they seem like they're not around. And then they later say, oh, I took a few days of vacation. You want them to put that in the system somehow. So then that way you deduct from their vacation accrual, because if you have a vacation accrual, for example, somebody accrues 40 hours of vacation each year. If you have someone who takes vacation, but they don't take a deduction from their vacation bank, or they don't record it, when that person leaves, if they are terminated or they resign, under the law, you're required to pay them whatever is in their bank that is accrued and unused. So if you don't have a record of them taking vacation, you'd have to pay out the whole 40 hours. If they actually took vacation, that doesn't feel fair, right? Because then you're overpaying them, but you had an obligation to keep track of it. So in California, you cannot have a use it or lose it vacation policy, meaning we give you 40 hours, but if you don't use it, then we're going to take away at the end of the year. And so you start over the new year with 0. That is unlawful. So I recently actually saw that with a startup where they had that kind of policy, and then we're working on fixing it and actually reinstating some vacation for people who lost vacation as of December 2024. Be careful with vacation and maintain good records of what you're doing. Again, going to the leave of absence piece that we talked about earlier, you need some good record keeping on leaves of absence. So I have packets that I give to employers, I'm sure other attorneys do as well, that say, hey, you've told me you're going to have a baby, you're going to go on leave, here's some information for you on what you're entitled to. Those are the kinds of records that you want to have, because if someone comes back later and says you didn't give me what I was entitled to, you want to be able to say, no, I sent you a letter in January, then I sent you a letter in March, then you were on leave for 3 months, and I sent you a letter saying, when are you coming back? And then you never came back. And so then we terminated your employment. But you need to have all those records in one place, ready to go, already sent out, created, so that you can defend if there becomes an issue. Performance records, if you're going to do performance reviews, make sure you're keeping records of that, right? And if somebody is not performing well, I think you really want to work on starting to document that. It becomes very difficult if someone's underperforming for 2 years and then all of a sudden you say, you're not doing well, we're firing you. And they say, but I just told my boss last week that I need a disability accommodation, and now I'm getting fired all of a sudden. Nobody ever told me I was underperforming. So keeping records of these things, very, very important. Also, all businesses need to have an illness and injury prevention plan and a workplace violence prevention plan. Those are 2 plans that you can get information on the Cal OSHA website. They have templates to help get you started, but you should also be talking with counsel about those. Workplace violence is a new requirement that launched last year and really has to be tailored for the specifics of your business. I think, there have been some pretty sad, unfortunate workplace violence incidents in recent years in California. And when somebody comes into the workplace and engages in violence, there's a ripple effect. And one of those ripple effects here is that the state wants you all to make sure that you're telling employees who they should go to if there's any kind of threat of workplace violence. So there's a lot of information that you can get publicly on this, but if and when you start working on that, you should get some legal assistance as well. Generally, we say to keep things for 3 years. So I say 4 years for all of the wage and hour stuff, records of overtime, wages paid, meal and rest, all of that. because if you're sued, they're going to go back 4 years. For illness and injury, that's 5 years. Workers' comp is 5 years. So just generally, you're going to have an obligation to maintain these records for a significant period of time. So you want to make sure there's no automatic overwrite feature or automatic drop off of anything for the stuff that you need to maintain. So again, for wage and hour purposes, things that you really need to be maintaining: the hours worked, wages paid, records of the paychecks or the payroll register, or actual copies of the checks that you can download from your payroll service, and personnel files. Because any type of employment action, you're asked for those things every single time. So make sure you have them. Notice postings. So I think we've all seen this, but I just, want to make sure that I mention it because it's something that is easy to not place too much stock in. Employers of all sizes required to post a bunch of different kinds of postings. I put the link there at the bottom, and if you go to that link, it has all of the notice postings that you're required to have under California law. You can pretty easily pull them. A lot of them are in different languages. So if you have a workforce that has some different language speakers in it, make sure that you pull the other languages as well. You can send them the notices via email. If everybody in your business has an email, you can send those via email and post them on the intranet. If not, make sure they're posted physically. If you have a mix of people who kind of work remotely and come in, I would say post them physically in the break room, whatever, and then also send them out electronically. Required training. I think for anybody who has worked a job before, you have probably had some required trainings, but we do have a requirement for anti-discrimination, anti-harassment, anti-bullying training in California for all employers with 5 or more employees. So you're supposed to train people when they're hired, really within 6 months, but try to get it done right away. And then every 2 years thereafter. It's 2 hours of training for supervisors, 1 hour of training for non-supervisors. The training for supervisors really has sometimes a different focus because supervisors are responsible for enforcing policy, whereas the non-supervisors, you're just telling them, these are what the policies are. This is who you should go to if you have an issue, right? But every single discrimination, harassment, retaliation case that you will ever get, the plaintiff's attorney is going to ask for copies of any training records for the supervisors, and they're going to want to see that the employee themselves also received training. And if you didn't do that, you're not in compliance with the law, and it makes it more difficult to defend that you did what you're supposed to do. The workplace violence prevention plan also has a training component. This was new as of last year, and it's for all employers. You have to do it every year, and you're required to implement the written workplace violence prevention plan and do the training. And the training and the plan are supposed to be specific for your business and or industry, like I mentioned. So if you have an office in downtown Los Angeles or, part of downtown San Diego, and there is a high percentage of indigent, unhoused people near your workplace violence considerations should take that into account. And they might be very different than someone that's in, Del Mar Heights, right? Or, West LA, or, the Bay Area in Palo Alto versus being in San Francisco. You actually have to take into account those specific issues. You have to take into account if there's been property crime in your specific neighborhood, or other violence, gang violence, robberies, burglaries of businesses, things like that. So you will probably need assistance with writing your plan and doing that training, but it is important. I think it's also important from the standpoint of you want your employees to be safe, right? And so you want them to know what to do if something happens. And it's pretty much always going to be call 911 and report it. But then who do you call within the company? If someone's working late on, some stem cell research, and then there's a shooting nearby, or they hear something crazy happening, what should they do? That's what this plan is supposed to help train them on. So final thing that we're going to talk about, litigation avoidance. So in my mind, this is one of the most important things that I do, because I know how challenging litigation is. It takes away from your business goals. It takes away from your bottom line. It's very expensive. It's very, very draining. And so if you have a goal of avoiding litigation, at least for the foreseeable future, maybe you'll worry about it less when you're, a really huge business entity. For right now, if you want to avoid litigation, what should you do? You have to be thinking about these policies and procedures that I've been talking about, getting them together, getting everything in order early, and really not waiting until you get sued. That is usually when somebody calls me for the first time. Either somebody has complained or they have an actual lawsuit and they're trying to figure out what do they do to defend it. And I ask, well, can I get your handbook? Can I get a copy of the meal and rest break policy? Can I get a copy of the time records? And they tell me we don't have any of those things. Like we weren't keeping track of any of those things. That's hard, right? If you have those things up front, I think the reason you avoid litigation if you have those things in place is it feels to employees like you are doing everything correctly. Employees do have a sense of, if I've got a handbook, I've got these policies being pushed out to me, this business is paying attention to the law. They actually do care. If everything is after the fact and you're paying payroll late and you don't keep track of anything and you don't have a handbook, employees might think that they can take advantage of you, and they can and they will. Make sure you're pushing them policies and procedures out to employees and getting their acknowledgement forms so that you have the record of this. And I think, again, it reinforces for employees that you are paying attention to the law. You have talked to a lawyer. You know what you're supposed to be doing. Even if you're not doing everything perfectly, it gives the presentation to employees that you care. Part of your employment handbook should be a complaint procedure process. And when you get complaints, you need to take them very seriously. Even if you think it doesn't sound that serious, if someone comes to you, you have to investigate. You have to figure out if something was done improperly. You have to take action. And you have to make sure that nobody retaliates against the person who complained. So that raises a whole separate kind of question under the law that we've all heard of, but whistleblowers, somebody who says, something is improper here, it needs to be fixed. That person is entitled to protection from retaliation for that if it's a good faith complaint. Even if they're wrong, they could be wrong because they could say, I think we're breaking the law in the way that we're reporting our clinical trials to the government. They could be wrong about that. But so long as it's in good faith, they're entitled to protection. Do exit interviews for people when they're leaving. Find out why they're leaving. Find out if there are things that you could have fixed. Do training. Especially training for supervisors and managers. The managers are the ones that are going to be there day to day with these employees, and they're the ones that could potentially get you in trouble if they don't do things correctly. If the manager is saying, no, you don't get to take paid sick leave, I need you to work, that's a violation of the law. The manager might not know that that's the law, though, because they haven't been trained on it. So really, you need to do training of everyone, but managers who are on the ground need some really focused training on what their duties are. To avoid litigation, also, when you do separations and you exit people out, consider doing separation packages with release agreements. So a separation agreement has to include some financial consideration. Typically, there has to be some consideration, usually it's financial, for them to be leaving. And then you get a release so that they don't come back and sue you. And it gives you some protection knowing that as people are leaving, they're not going to sue you. But of course, there's a financial piece to that. And then, develop a relationship with an attorney that you trust for these HR issues. There are a lot of other things that could come up here. I hope that you have found this helpful. And if you have kind of follow-up questions or you want to reach out, I'd be happy to talk to you. But I hope that this was useful. So thank you so much.